success stories. The two success stories we're mainly talking about, one is the humanitarian urgent expedite requests. The other is a mandamus action where we sued the government December last year, and then we got all the cases approved. So that these two success stories I want to share. But I'm going to start with the bad news, and it's about denaturalization. So I know last week I was very open and wanted to comfort people and talk about denaturalization and tell people not to worry. I got some of those wrong. And essentially, if I boil it down, that previous video, I'm essentially saying, look, 300 cases for denaturalization over X amount of years is a very low number. People don't need to be concerned. A lot of these people might have already left the US or commit major crimes. Right after that video released last week, I think it was just a couple of days ago, the Department of Justice released their statement about what they're processing right now with denaturalization and the 12 cases that are ongoing right now. And so I have a lot to share about how I'm wrong. So the first thing I'm wrong, the 12 cases that got released, almost all of them are in the United States. Okay, so it's not like people who have already left, they're all in the United States. The second thing that I was wrong was that this 300 number for so many years compiled together, and now they're being processed. That has gone up significantly. Their goal is 100 to 200 cases per month. So now we're talking 1,200, 1,800 cases a year. Still, like I said last week, if we're naturalizing 800,000 cases a year, 10% of it is 80,000, 1% of it is 8,000. If every year they denaturalize 1,000 to 2,000, that's still way under the amount of cases that actually do get naturalized, especially there's so much backlog of the past 10, 20, 30 years of cases that they have to denaturalize. So it is still not a major concern, but it's definitely what I was saying last week. Now, we dug in deeper to find out what the details are on these 12 cases. And there are something that is quite concerning because previously, everybody's been concerned about, oh, my green card application had some errors in it. My naturalization application had some errors in it. Should I be worried? That is probably 99% of what people are worried about when they think about naturalization and green card. However, these 12 new cases that got released, and when we looked into every single specific fact about these 12 cases, we find out a lot of them, I think there was 5 of them, that the reason to denaturalize, there's two of them, right? Galen reviewed it very detailed. 2 of them is because of actions taken after they got naturalized, which means now there's a new reason to be worried. If after you naturalize, your action can cause you to be denaturalized, what does your naturalization even really mean? Is this a new era where there's a probationary citizenship that is not on the books, that is not in Congress, but somehow you can be denaturalized due to the actions you commit after you've been naturalized? Now, the reasoning from the Department of Justice is that, well, based on their actions after they got naturalized, it proved that they lied prior to naturalization. This is still in court. I'm sure it's going to be challenged, and we'll see where it goes. But this is the line of thought that is happening. Now, all 12 of these cases are all pretty serious offenses. So, like I said last week, people are not getting denaturalized because you had a typo. People are not getting denaturalized for an innocent mistake. People are not getting denaturalized for something where you can get your green card taken away, right? Like if you've traveled a lot and you might have been presumed to have abandoned your green card, you could get your green card taken away. If you traveled a lot, you didn't meet the physical presence test or continuous presence test, and then you naturalized, and then an officer used their discretion and approved you when another officer might have denied you. These are not the type of cases that are being denaturalized as of right now, at least. The cases that we're seeing are major crime rings, serious offenses, identity theft. They're a part of a huge fraud immigration ring. And so this is the stuff that we're seeing. Now, again, 1,200 to 1,800 cases being denaturalized every single year is definitely a huge jump from the 300 that we talked about last week. But the infrastructure, and something else that's really concerning is that the Department of Justice said they've built out their process. So they're ready, they're staffed, and they're ready to go. Now, they've been doing this since the Obama administration. So they took several years, half a decade to get to where we are today. So I'm not surprised. I am surprised by how fast it moved from last week, 300 cases, to now, aiming for 100 cases a month, to 200 cases a month. But all in all, this is something to continue to pay attention to. I've been following this news since it was announced back in the Obama administration. And this is something that people need to be aware of, right? So once you get naturalized, it is definitely not the end. Now the government has the ability to even call back your citizenship after you got it, based on what they presume that you must have lied prior to your naturalization. So essentially, those two cases is after you naturalize, within the 5 years, you committed a major crime. Well, if you committed a major crime so quickly, you must have violated your oath. So we're going to denaturalize you. So this new probationary citizenship is definitely happening, and we are going to see what happens. So that's the news for today. Again, I still don't want people to panic if it's just a small, minor thing, but I'm going to take questions, and then we'll get to the 2 success stories in a bit.
Okay, so feel free to add your questions in the chat. I had my I-130 approved today from my interview 2 weeks ago. How long will it take for my 485 to be approved?
You had your I-130 interview approved? Or just I-130 approved?
I-130 approved.
Okay, so I'm presuming your I-130 and 45 was filed concurrently. I-130 approved. Usually 45 follows really quickly, whether or not you get an interview. If you get an interview, then you ace the interview, and within a few weeks or a month, your green card should get approved. So that's it usually follows pretty fast. 45 is usually a much faster to adjudicate than the I-130.
I have an NIE for the 75 country pause, pending a response for 65 days. The last update was that my case was forwarded to the chief visa officer. Any chance that I can still be approved for this EB2 NIW?
Just keep on waiting, right? Things are just taking extremely long. Doesn't harm to file an update. Doesn't harm to have your clients, your hospital, or anybody reach out to the congressional inquiry and have congressional inquiry follow up with them as well. Those also help, right? Basically show, well, why is it so urgent for you to come when everybody else can't?
I have a pending change of status from F1, and I received a NOID. I responded, but the case was denied due to failure to respond on time. Now I have tracking proof. What options do I have besides filing a motion? Was PP.
Yeah. It's sad to say a motion to reopen might be your only recourse, other than everything else that you could have done as well, right? So you could leave the country and get a new visa and come back in. If your visa is still valid and your passport is still valid, you could leave and try to re-enter at the port of entry and have the CBP officer approve it. But assuming you didn't do those 2 actions because you didn't want to, and you filed a change of status or you filed a reinstatement, and if it wasn't approved, the NOID was denied, your motion to reopen is the only thing you can do.
As a Canadian, if my American partner files a K1 visa for me, can I still fly back and forth?
You would want to explain to the customs officer that you are just a tourist right here, right now. You don't plan on adjusting. You don't plan on changing a status. You're still examining the relationship, because the whole point of K1 is that you're essentially dating. You're going to come in and you're going to get married after you come in. So even though you have somewhat of an immigrant intent, you have a U.S. citizen boyfriend, don't hide that fact. If you I've seen so many clients not disclose that. CBP officer looks at the phone, finds it, and then says, well, now you lied. And so now I'm going to deny you, and you have 5 year ban, you cannot enter, right? So don't hide the fact, be truthful, but you're still in a somewhat complicated relationship, not yet sure you're going to move forward or not, but you definitely are not going to get married and adjust status. Right now, you're just coming to see, Statue of Liberty, Disneyland, the World Cup, be very clear on your intent.
Okay, this, I'm going to give you the situation. I have an H-1B, which expired in 2020. I left the US just after my contract finished. I still have 4 years of recapture time. Currently have a valid B1, B2. I've been offered a new job, same project site, this time different employer. Soon, I'll enter on the B1, B2. Can I renew my expired H-1B even if more than 6 years have elapsed?
I believe you can. I believe we've done it, but I have to double check. But I believe you can.
And can an H-1B transfer be processed under these circumstances?
It is possible. You have to be very careful because B1, P2 change of status to H1B is gravely frowned upon nowadays, right? Again, in the past, there wasn't this official memo that came out. But in the past, as long as you fulfill the change of status requirement, they almost have to give it to you, right? So you come in, you wait the 60 days, you wait the 90 days, you have an urgent reason why you do the change of status, and then you do the change of status, and you prove you did not lie to the port of entry officer, it was beyond your control. We've almost seen every single case get approved in the past. Then the memo came out last year. I don't exactly remember which memo, but it explicitly said, even if you meet all the requirements, it is still discretionary on the officer. So if they don't like you, if they don't like the case, they can still deny. And if they deny, then your B1, B2 actually gets canceled. You have to leave the country, and you have to do the H1B abroad, and then you have to pay the 100,000 fee.
So will this, if everything goes accordingly, will it be subject to the 100,000 fee?
No, if you do a B1, B2, enter the country, change the status to H1B, you do not pay the 100,000.
How far in advance do you recommend to renew DACA?
I would recommend doing it the day you're allowed to, which I believe it was 6 months. I mean, Gabby knows
180 days, right?
180 days. That's what I remember. The DACA department would know for sure, but immediately. The reason why is it's taking sometimes 9 months to adjudicate DACA. So you don't want to be without a work permit, right? Or else you're going to have to take 3 months leave of absence.
Why can't I file for my spouse right now? They're saying my wife's country is on the ban list.
Well, because they're on the ban list. Why are there certain countries on the ban list? Because of this administration deems certain countries to be adverse to national interest.
Do you want to go to church with me on Sunday?
I already go to church on Sunday. Do you want to come to my church on Sunday?
I'm married to a U.S. citizen, entered without inspection, no advance parole. How long is consular processing plus waiver taking?
Say that again.
Married to U.S. citizen, entered without inspection,
okay,
no advance parole. How long is consular processing plus waiver taking?
Okay, so you file the I-130. That could take about a year. After the I-130 gets approved, you do the National Visa Center and Consulate, which let's just say about 6 months. Then you'll get the denial inviting you to do the waiver. Right? Inviting you is a very nice way to say your case got denied, you have to do a waiver. But you knew that, so that's not a problem. So this entire time you're building up your waiver case. Then you file the waiver after the consulate denies it. Hopefully you could file a 601A. Then you wait for a 601A, which 601A processing, I believe it's 2 to 4 years. It goes up and down. You can always do expedite request. And then once that gets approved, you spend a week back in your home country, go to the interview, get it approved, and then come back. And then a month from then, your green card gets mailed to you.
Okay. I worked without authorization while my change of status was pending back in 2021 to 2023. And I lied on my I-539 regarding employment.
Okay.
Now I am married to an LPR outside of the US. Okay. Will aging out in 5 years avoid 6C1?
That is really complicated. There's so many. You know what? This is such a good question. Um, I'm actually being a USCIS officer at the AILA conference, and I'm supposed to role play a very strict officer, come up with hypos. And one of the goals is to try to come up with a scenario with as many reasons for denial as I can. This scenario actually comes close to qualifying for one of those because, well, first, if it's an LPR overseas, they might actually have a hard time petitioning you, right? I-130 could get approved, but at the consulate interview, if they don't have physical presence in the US, that could get denied. So that's one reason why it might not work. Second, if there is unlawful status and you need to file for waiver, then you need to file for a waiver. But if your LPR spouse is overseas, that waiver is going to be extra hard to argue. So the waiver might be denied, and therefore your green card will be denied. Does unlawful work amount to an inadmissibility? Is it a fraud and misrepresentation? No. So working without authorization doesn't amount to an inadmissibility, which doesn't require a waiver. However, lying on the 539 is an inadmissibility, would require a waiver. So, yeah, it's a very difficult situation. My recommendation in this scenario is for the green card holder to get back into the country and use a 4-year 1-day rule or the N470 rule, N470 application. Use that to try to naturalize ASAP. And then once they become a citizen, they can petition you, and the waiver process, all that becomes much more smooth.
What if aging out for 10 years because the waiver success rate is so low?
You know, I wouldn't say waiver success rate is low. I know online, I know ChatGPT, I know a lot of things say it might be low, but compared to what, right? So I think it's important for you to really understand what the requirements are and really understand how other people are filing. And that's why we do so many 601 waiver videos. It's not like this case got approved, this case, these are the facts, these are the background, this is the argument, this is what we did. So you can kind of see, well, what actually is working instead of just like a random number, right? I mean, we hear it's low, but we see a lot of cases get approved, you know? And so if you work really hard, it might be possible, right? So don't be disheartened by that.
But aging out for 5 or 10 years, does that help?
It definitely helps, right? The longer time has passed from the criminal offense, and during that time, you could show you reformed, you're good, you contribute to the United States. It definitely helps your case, right?
I got biometric RFE for H-1B renewal and my I-140. Is that normal?
Biometrics RFE. So a request for evidence for you to do a biometrics. I usually don't see that unless it's for an 829 EB5 investment. But biometrics is very common, especially nowadays. The new administration, I need to stop saying new. They're not new anymore, right? They've been around for like 2 years now. This administration just released that they want everybody to do biometrics again, right? So again and again and again. So it's not, uncommon. Everyone has to do it now.
Is it something to be concerned about?
I would not be concerned about it.
Can I get denaturalized if I was never naturalized, but I was born abroad from 2 U.S. citizen parents?
Much more difficult to denaturalize you.
Right, because denaturalization has to do with misrepresenting yourself during the naturalization process.
That's exactly right. Galen took it right out of my mouth.
Yeah, sometimes I get too excited. I filed I-751, join. It's okay to work in different states?
So if your question is, I got married, I got a green card, but we live in different states, we work in different places, will the officer see that as a fake marriage and deny my case? Another way to ask the question is, in order to get a green card, does every single bona fide real marriage require 2 people to live together? And when you put it like that, the answer is obviously no, right? You could live separately and have a real marriage, but the burden of proof is on you, right? because it is definitely uncommon, right? Would you say 95%, 90, probably more higher than that, probably 99% of marriages live together. So if you guys don't live together, you really give 100 reasons why.
Now they lived together for 3 years.
Oh,
first, and now they're
Okay.
separating, or just
living in a separate
Yeah,
place.
exactly.
Okay, so make the argument, right, that your marriage hasn't fallen apart. But just know, even if your marriage fell apart, you could still get the green card through the 751 waiver process, right? So you just need to be able to explain this is a temporary relocation. It's very important. We both have our careers, but this is still a real marriage.
Is it normal for USCIS website to no longer show the month remaining? Should I be concerned?
I'm not sure what you're talking about. Yeah. So maybe screenshot it, send it to us.
Any updates on the pause 75 countries?
I haven't heard anything. It's definitely still ongoing.
Right. Yeah, there were a few lawsuits getting preliminary injunctions about the 39 country USCIS pause.
Right.
But
not the 75 country.
Yeah. I got a notice of intent to rescind green card after approved for fraud misrepresentation.
We've seen those. It definitely happens. And
the misrepresentation is from a visa form years ago.
Yeah.
I put common law marriage.
Yeah. So there's two potential possibilities with this notice of intent to rescind. One is definitely worse than the other. One possibility is that the officer is saying, you didn't even qualify to get the green card in the first place. You don't meet the basic requirements. Your marriage was not valid. So you can't get married. Or they might say your prior divorce, your prior marriage wasn't dissolved yet. And so you don't have the basis to file a new one. So fundamental basis to meet the green card eligibility, you did not meet, so you can't get the green card. That's definitely more serious than you lied on your application. Because if you lied on your application, then it's fraud and misrepresentation, which means you're eligible for a waiver. And if you're married to a US citizen or a green card holder, you can still reapply for that green card and you can reapply for the waiver. And you can do it at the same time with the officer. And we've seen that, and cases have gotten approved. But that's only if it's fraud and misrepresentation, right? But if it's like you fundamentally didn't even have the basis to even apply, it's fraud and misrepresentation, and it is, you don't meet the eligibility, so you can't even file a waiver. So it depends on your case, but depending on it, you might still have a chance to still get the green card.
I've been on admin processing for 24 months in the Montreal consulate for my green card, F2B. As a Canadian citizen who was born in Iran, should I file a mandamus? What's the best course of action?
Are you a Canadian citizen?
Yes.
You should press them again, right? And say, look, I qualify. I have dual citizenship. I shouldn't be admin process for this long. Have the U.S. citizen. Oh, you're F2B, or no, F2A, right?
F2B.
F2B. Okay. Try to get the congressman in the U.S. to try to press them a little further on that. Right? That will help, because the consul is just gonna sit on the case. So you have to give him pressure.
I'm on F1 student visa, and in my DS-160, I said I don't know anyone in the U.S. Can my father, who's a U.S. citizen, file now?
So when you file, just know that your adjustment of status application, the officer will go back to your DS-160. They can if they want to, and they will see that. And if they piece together something that doesn't quite make sense and they feel like you lied, then they might force you to do a waiver. Now, if your father is a U.S. citizen and you're in the U.S. and you're taking care of him and he really needs you, you might qualify for a waiver. So it might be okay, right?
Now, on this 751, their taxes credit card shared under same address, and they visit their wife every month. So will that hurt their case?
It won't hurt your case. Yeah, it will help your case. But if your question is it sufficient? The answer is no, right? It's really hard to say when a certain document or documents is sufficient. It's up to the officer to kind of look through everything and then make that determination, right? So if you are an officer who thinks every single case is fraudulent, would you believe that, right? It's so easy to put, joint tax returns and address, and you visit each other and you smile and take a selfie each month, but does that mean it's real? So you definitely want to really prepare.
And you're not penalized for submitting too much.
Exactly. So don't bank on that being enough.
A family member has a... one second. Family member has a current/valid visa TPS from El Salvador. He is married to an LPR holder. Is F2A visa viable for him to start his adjustment process?
Sorry, blinked out. Say it again.
Family member has valid TPS from El Salvador. Married to a green card holder. Is F2A viable for him?
Yeah, but priority date, right? So file the I-130, wait for a TPS, and hopefully it continues, and then you file 45 when it's current.
Do travel bans still exist for Haiti? One of my buddies just got approved for 45.
Well, if you got approved for 45, that means you're in the U.S. And then if the 45 is approved, then they get a green card. And if they have a green card, then they're much safer. Now, I have to go back and check. If you're a green card holder and you travel to Haiti, can you travel back, right? And if I remember correctly from the first administration, if you had a green card and U.S. citizen, you can still come back, right? So the travel ban is for people who don't have green cards or citizenships.
On this admin processing for Montreal, the congressman in California said USCIS advised them not to send.
Okay. That is really interesting. I've never heard that before. The congressman said USCIS recommended that they don't send the inquiry. Is that right?
Yeah, the congressman. Okay, more update. The congressman said they can't do anything.
Okay.
And they've been hearing different things from different attorneys. Some say mandamus will do the job. Some say it doesn't. What do you think?
Mandamus to the consulate rarely moves the needle. Today's success story is we did 5 mandamus and they all got approved. But that's because they're doing adjustment status in the U.S. If it was overseas, we wouldn't have recommended it. Now, I do know a few law firms here and there that have done the mandamus, try to go through consular non-reviewability, try to sue them, try to move the needle. A lot of them take years. A lot of them, I haven't heard much success. But mandamus is something that happens every single day if it's done in the U.S. So if you have unlimited funds, you want to try it out, that could be something to do. But the success rate is very low.
Okay. Being a resident with a DWI charge closed in 2024, would I have problems returning to the U.S.?
If it's one DUI, shouldn't be a problem unless it's a drug-related DUI. Even if it's expunged or closed, USCIS, CBP could still see it. So we have seen clients with a green card having an old DUI, drug-related offense, still get detained for weeks.
Do you have any dealings with E3 visas? I want to travel, but I'm worried I might not be let back in.
So that's more of a CBP question, right? So you already have the visa, you want to travel. It's just when you see the customs officer, can you convince them? So yes, we do deal with customs very often. Doesn't matter what visa category you're on. But you can also just prepare the package really well to show, look, I did not violate my status. I still have the visa. I'm still working in the U.S. That's what they care about, right? It's a short trip abroad and you're coming back.
Okay, 2 follow-ups on this 751. Sometimes they waive interviews if you have good enough evidence. Is that true?
In the past, yes. They have said they're trying to do lottery interviews. So even if you have really good evidence, they still might call you in. And we have seen that with some of our clients. Really good application to get in. And the officer says, don't worry, I'm going to approve you guys. This is a formality. So I'm going to ask you some questions, right? And so is it possible for you to have your case waived? Yes. I just wouldn't think too much about it.
Okay. And then follow-up, is what's the worst case scenario?
Okay.
So this again, so some reminders. They lived together for almost 3 years.
Okay.
Now they're going to work in a different state,
Okay.
and they're filing the 751. What is the worst state? Will they deport me? Worst case scenario, and will they deport me?
Well, yeah, if you really want to go extreme, worst case scenario, you go to the interview, they ask you some questions, you answer so poorly and it doesn't match a thing, and so many red flags. The officer leaves the room, calls the USCIS fraud inspector. They come, they do their assessment. Then they, deputized by ICE, handcuffs you and takes you over to the ICE detention. And then ICE takes over and then detains you, and then gives you a notice of intent to appear. And then now you're in detention, and then you're going to be removed, right? That is the worst case scenario. We've never seen that with our cases. There are plenty of worst case scenarios that before this possibility, a possibility that's also pretty bad is that they said, okay, well, I believe you, but I have to pass it on for investigation. So you leave the interview, and now there's an FBI that is checking your marriage, and they're going to both of your workplaces, your spouses, your workplaces, your friends, your neighbors, and it becomes a 4-hour administrative processing after the interview. So that it's painful for a lot of people, right? Obviously, if they say nope, I think you guys are already separated, you should have filed a 751 application, waiver application, not 751. So we're going to deny it. You're going to have to go back, refile everything, pay a new fee, and re-wait another 3-4 years. That's also pretty bad, right? So there's a lot of different scenarios that can happen, but I think I wouldn't worry about that. I would just worry about building up your case as good as possible. And then if you have an interview, go in and show, right, that everything is good.
So following up on the mandamus, they're a Canadian citizen born in Iran, and they applied with their Canadian passport. Are they exempt?
Well, based on the notice that we see on the for the national, I forgot what the website, but yes, if you're dual citizens, you're exempt, but they still go through administrative processing. So that's the part where it's like, well, you're exempt, then why are you still doing such a long admin processing, right?
And then do you think it's a waste of money to file the mandamus, or they'd be better off to just wait it out?
My personal opinion, and on behalf of the firm, since I kind of own the firm, we do say it is somewhat of a waste of money if you're doing a mandamus for a consulate.
Right. And can you explain a little the consulate non-reviewability?
Yeah. So the consulate, they don't have to report to the courts in the U.S. Generally speaking, they have a consulate non-reviewability clause, which means they just don't have to answer to another department, the Justice Department. They fall under the executive branch. So they're admin processing for too long. Oh well, that's their prerogative.
Under Biden, asylum removal returns under ruling, Immigration and Nationality Act.
I don't know.
I'm from one of the 75 countries banned from green card. Do you think it's worth applying for EB2 NIW? Because they have the national interest exception.
Oh, okay.
Well, yeah, they have the NIE hasn't been approved for them. Just in general.
I see. Yeah, of course. Yeah, apply. Right. There's no harm applying, and once you get things approved, then you have different options, right? Because let's say you get that approved, and then you get the exception, then you can potentially get the green card overseas, or you could do a O1, come to the U.S., and then now you can adjust status in the U.S. Right? Presumably that your EB2 and NIW is approved, right? And so, yeah, if you qualify for something, definitely apply for it.
And we haven't seen an NIE for the 75 country ban approved yet. Is that right?
Yeah, at least I haven't.
Okay. Okay, so I want to get to, we have a few success stories, so I want to get to one. Still feel free to put your questions down in the chat, and we'll get to them after the success story.
Okay, so I'll do the mandamus one first, because that's the one we prepared, and then we're going to do about the humanitarian expedite request right after. Today's success story is about mandamus action, and it's so important to give you the specific timestamps because every single month things are changing and you don't know, but it's really important to actually kind of see, oh, this is what somebody else did. And this mandamus action, like most mandamus actions that we do, is almost like a class action, right? We pull a lot of people together and do it all in one go. It saves them cost, it saves them time, it saves everybody effort. We all work on it together and we just win 5 cases simultaneously. There are still 5 separate cases, and they get adjudicated separately. But the main action, going through the main flow of the mandamus, is all at the same time. So let me give you the dates, okay? We officially filed the mandamus December 2nd, 2025. And it's for 5 different cases. The first one, they filed the 526E, and their 45 is pending. Their adjustment status is pending. They filed it back in August of 2023. The second client filed their 526E in November of 2023, and they're waiting at the consulate. The third case, they filed it in November of 2023, and they're also pending 45. So, a lot of these people came in with a tourist visa, and they filed for adjustment and the 526E. And then another case was they filed in February of 2024, and their 45 is pending as well. And another case is just the 45. So 5 different cases. They've been waiting for close to a year and a half to 2 years. Well, in this case, some are like 2 years and 4 months or more. And they just had enough. They did not want to wait any longer. They each invested over $800,000 into a particular project for their entire family. And they're stuck in the US and they're waiting on the 45. They're legal here, but it's sort of all in the air. And so they had enough. They didn't want to wait any longer. We filed the mandamus action in December. I think we officially started the process, I think, in late October, early November. It took a month and a half to prepare everything. We officially filed it. Now, all of these cases, including some of the 45s, have been now approved. There was some up and down throughout the entire process. So we filed it in December. Right now it's already May. So in the past 5 months, there's been multiple court hearings and there's multiple court dispositions and motions to try to close the case, try to extend the case. The government wanted 90 days. We didn't agree. We wanted to short it to 60 days. And within the 60 days, they already approved some of the case. They issued the RFE. We answered the RFE. The case got approved. So there was a lot of action. Much more action than we've seen from previous mandamus cases, right? Previous mandamus cases, we filed it. I mean, within 2 months, hopefully, just cases get approved. It's like there's no reason for this crazy delay. You're just too busy. So just prioritize our clients, right? Because we filed the mandamus. And a lot of times within a month, 2 months, or 3 months, just cases get approved. And once the case approved, USCIS just tells the court, like, the case got approved, this case is moot, please drop the case. And then we say, yes, we're willing to drop the attorney fees because we're suing the government for attorney fees, right? So we're dropping that. That's how it was done in the past. But now there was so much back and forth. They wanted it in 90 days. They filed a notice of it to appear in immigration court. Like, what? Right? That's a separate trial because we filed mandamus in federal court. But now there's like additional immigration court that the client had to go to for the 45. And so there are so many battles we had to go through at the same time. But eventually the request for evidence issued, the NOID's issued, we respond, case gets approved, this mandamus finally can get dropped. The trend that we're seeing is that the government just really opposes everything that we do, right? Even though processing a 526E 45 case taking more than 2 years is outrageous. When the RIA came out, I think in 2022, there was a big announcement at AILA, and everybody was saying, processing time for investors was going to be like 6 months to 9 months. And there were cases that got approved within 6 months. And you can hear the thousands of attorneys go like, wow, like it was insane. Because prior to this, the old EB-5 program, people had to wait like 3-4 years. And now, with the new reform on EB-5, 6 months to 9 months is a miracle. And that's what they were aiming for. And people were getting it. And the actual adjudication time for a lot of these cases was supposed to be just, maybe an hour or 2 hours. So if it's an hour to 2 hours to adjudicate something this complex, but you're taking 2.5 years, there's something wrong. And so we did this mandamus action, and yet they still pushed back. And they didn't even push back nicely, you know? If they pushed back saying, oh, sorry, we really need more time, give us the 90 days. We said, no, that's too long, 60 days, fine. And then they just take their sweet 60 days and then they prove it. That is something we're okay with. But instead, they're firing off all these requests for evidence. And some of them are pretty bogus in the sense of like, oh, you need to do another health report, medical checkup, right? It's like, okay, we already did it like 2 times, sure, all right, did it, send it in, case get approved, right? They're just like creating work to do. It's like little kids. It's like, oh, you don't have anything to do. Here's another, color this sheet, right? It's just like a busy work. But that's what we're seeing. But when we did it, and then now there's no reason to deny. Now, I have also seen a couple other cases where people did the mandamus and they got annoyed and then their cases got denied. So I don't want to tell everyone if your case is taking a long time, just do the mandamus, because you only want to do a mandamus if you have a strong case. Because all it is, and we didn't just do the mandamus, we did mandamus and the APA, right? The Administrative Processing Act, where we're essentially saying they're not doing their job. All it does is just to force them to do it faster. So if you have a weak case and they do it faster, they deny you, right? And so you really only want to do it for these strong cases. And these 5 clients, they all had strong cases. They all believe in their case really strongly. So that's what we did. We didn't do their EB-5. It was another law firm, but they don't do mandamus cases. So it's like, so that's why we do a lot of EB-5 spin-offs, right? Where it's like, we don't necessarily do the entire 526 or the 829, but a lot of clients, they got the green card, they leave the country for multiple years, and now they can't get back. So now that law firm or the client hire us to deal with them at the customs office, right? Or they filed the case, but again, now they got annoyed. Now they got a complicated source of fund issue that they couldn't deal with. Okay, then we get hired, right? Or they have to go to ICE detention. For what? Because they got a notice to appear, but the case wasn't even denied yet. Well, now we go with them to the ICE check-in, right? So these are called EB-5 spin-off situations. It happens with all sorts of different case types, but we're really glad that the mandamus worked. We rarely do one mandamus action because it is actually quite expensive to do a mandamus because we're locked in for maybe like half a year to a year. There's multiple court hearings. And you never know what the government has to do. And we don't like billing by hour. We like just flat fee, right? We're set up that way as a firm. I know a lot of lawyers do hourly billing. We think that incentivizes the wrong incentive. And so we want to do, just, flat fee pricing. But if it's flat fee pricing per individual, per case, it's too expensive. So in this case, we were able to pull 5 people together to do it. And it made sense, right? But it worked, and so we just wanted to report on this approval. We were just the last of the 5 approvals we got May 13th, so just a couple days ago, right? That's the first success story. And if you have questions about mandamus or you're thinking about it, feel free to do a consultation. Happy to talk to you. Just book us on online. And again, this is Grace's team that powered through this whole process, so feel free to book with her. Now we're going to do the second success story.
Okay, and we'll take some questions beforehand.
Okay, go for it.
So 751 pending since 2024. Could they detain me for a dismissed, expunged case?
The answer is yes, right? So we had another client who had a green card already, a 10-year green card, had a 10-year green card for almost 10 years. 60, 70-year-old, no, more than that. He's closer to 70 years old. Wife, U.S. citizen, children, citizen. They could have gotten a citizen years ago. He just chose not to. Anyways, point is, he got detained. Okay? Why? Because the criminal offense was a drug-related offense years and years ago. So if your question is, can they detain even green card holders or people who are, the answer is yes. It depends on what offense it was. Expungement doesn't mean anything to immigration because to them, that's just a state court system running its course, but they are federal officers. They can make their own determination. Is that fair? I agree with you. Doesn't seem quite right, but that's their authority.
How long before I get my physical green card after the immigration judge approves my case?
Typically, it should be within 3 months. But if things are slower, okay, give them a little longer.
Why did the judge not accept the bona fide and action deferred as defense in court?
What are you talking about? Let me think. Why did the immigration judge not accept what? Deferred? I'm not sure.
Bona fide deferred action.
I don't know what that is.
For 750, the 751 detain me. The dismissed expunged case was petty theft.
Oh, then yeah, that's not a problem. Because for a green card holder or green card application, you could always use the petty theft exception as well.
ICE expedited removal certain asylum seekers without ruling that it was a misinterpretation of the law, no hearing or fear meeting.
Say that again?
So ICE expedited removal some asylum seekers without ruling that it was a misinterpretation of the law. There was no hearing or fear meeting.
I see. I don't know. We don't do asylum cases here at the firm, so that sounds like a very specific asylum type question, and they would probably know if ICE definitely violated the Constitution.
Why is DACA approvals taking so long?
Because it is just a low priority for the government, and it's been decreasing and decreasing and decreasing. So to them, it's not important. They want to cancel it if they can. They can't, so they're just going to delay it. At some point, is it going to get so long that it's practically canceled? And should you sue the government over mandamus for it? Maybe.
Oh, bona fide and deferred action under the U visa.
Oh, we don't do U visas and we don't do asylum, so that's why we don't understand. Yeah.
Okay, so again, we'll go to the second success story. Feel free to keep adding questions and we'll get to them after the end.
Yeah. Last week, I talked about a success story where it took 6 weeks to get an expedited advance parole, and I was like shouting hooray and celebrating. Just today, we got 2 more, and it was a 1-day approval. And so I want to share about this because this is a huge, huge change. I have been on listservs after listservs with different attorneys talking about expedited processing for these emergency humanitarian situations, and almost every attorney in different listservs and in person and at the conferences say they've tried, it just doesn't work, right? Even in COVID times, I remember there was a case where the officer at the InfoPass agreed to approve a case, send it to USCIS, and then USCIS comes back and denies it, right? Even within USCIS officer approving it and trying to expedite, still got denied. But seems like the process is working now. So let me explain a little bit what I'm talking about. Let me explain a little bit. If you are in a situation where you need an expedite processing for something, right? So in this case, it was 2 different things. One was for a green card interview. For one case, it was for a case that was already denied. They're about to, be sent out of the country, but they were able to go to USCIS office and actually reopen it without actually paying. So that's huge. So that's one success. The other success is the applicant's grandmother was passing away, and they needed to go see them. But normally it could take 4 or 6 months before advance parole comes down, but they need to go immediately, right? And so the success story we did last week was about how we did it in 6 weeks, all the different process. But now the client went to the New York field office, talked with an officer, emergency appointment. They listened to the reason. They questioned very specifically about the grandmother's condition. They looked at the documents. They looked at the written attorney brief explaining the urgency. They looked at the plane tickets. They asked about the plane tickets and the return tickets. They asked what they were doing now. They asked about the dosage of the medication. All super specific, right? It's not just like, oh, my grandmother's passing away. Can you expedite this? It's, tell me about your grandmother. That's your reason? Is there any other reasons? Where is she right now? What are you doing? Like, it was a lot of detailed questioning. But at the end of it, right, it was maybe like a 20-minute investigation talk. Went to talk to a supervisor, came out, printed out the I-131 advance parole, laminated it just like it was pre-COVID, gave to him, and now the client could use this as an emergency advance parole, leave the country and come back in. And it was just done right on the spot, right? Paid on the spot, printed out on the spot, laminated on the spot. I mean, it's one of the most expensive laminating sheets, but it's an emergency advance parole granted the same day. We haven't seen that in years. Maybe around the country, somewhere else, somebody has done it. We haven't seen it, but it's working now, and I'm so happy the client is able now to leave the country, right? So that just happened like a couple days ago. Just today, this morning, this is what happened, right? So again, I'll walk you back. A couple days ago, the client missed their appointment. This is their green card appointment. They missed it. They've been waiting for several years for this appointment, by the way. They missed it. They didn't see it. It was a very humanitarian situation. Wife just gave birth. It's understandable, but they missed it. But what's the normal recourse? They get denied. They leave the country. They apply for consulate overseas. Think about how complicated that is, right? Father, mother leaving the country, leaving the work. They've been here working for several years now, legally, right? U.S. citizen baby have to bring abroad just because they missed a single appointment notice. And they didn't even get the mail. So I advised them, go to the field office. It's a long shot, do emergency info pass. They might not accept you. Do the phone and prepare the paperwork, file the motion to reopen, at the FedEx office downstairs if they don't see you, right? That's all you can do, but just try your best. They went there, the officer wouldn't see them. But before they mailed out the 290B, the client was able to think on the spot and said, you know what? What if we went upstairs to where the interview is, right? And so I'm like, yeah, great idea. Go ahead and ask them, you're willing to do the interview right now, right? Or at the very minimum, at least, just reopen the case and reschedule. They went there, they waited, the officer heard their situation, gave it to a supervisor, the supervisor gave it to a director came out and personally reopened the case and gave them an appointment. You think it's something so simple. Of course, this should be done, but it does not happen, right? It just does not happen, but they got it done. And now they don't have to worry about having to leave the country. And so, all the complaints about USCIS, about ICE, about CBP, there's still people working on these things. And when you have a sympathetic situation, when one officer isn't willing to help you, like the InfoPass officer downstairs wasn't willing to help. I've seen other officers on the 6th floor at the USCIS office say, nope, we can't do anything. It's an InfoPass issue. Send it back down to them. But this officer said, you know what? I'm going to take a look at it. Take it, give it to another officer. Another officer was like, you know what? I'm going to give it to a director. This seems something that's sympathetic enough, right? And again, they were able to do it that day, and it worked. So I just want to share these real life situations that's happening right now so people could see if something like this happens to you. You miss your appointment. Your case is going to get denied. You waited for 2 years, and now your whole life is going to change. But by not giving up and going to the right place, talking to the right person, your life can get completely turned around. So I'm so happy that both of these cases got approved. It seems so small, but so big all at the same time, right? And then also the Mandamus case, which is a big case for these 5 families. And they don't even live in the same place, right? One lives in Boston, another lives in California, another lives in New Jersey, another lives in like somewhere. I mean, and 2 lives in, like overseas, right? Because they're waiting for the consulate interview. But we were able to force the government to approve the 526E. We were able to get the government to approve the 45, and the clients are all able to get their green cards and finally be able to resume their life. The immigration system is very broken because the system is run by people, and when you have HR issues, when you don't hire enough people, when you force people to get furloughed, when you increase a lot of responsibility, the system breaks down. But there are still good officers everywhere, good judges everywhere. Prepare your case well, and there's still hope. That's the story for today, right? The 2 success stories and the news that I wanted to share. I'll answer some more questions before we close out the live.
Sounds good. So would you recommend not traveling for work to a different state on the 751 case, even if the relationship continues?
Like I said, if you can prove your marriage is real, just do what's best for your family, right? So if you need that income, if it's a good income, if you guys are jointly building something together, know that it might make your immigration case a little weaker, but if you have really good explanation, that should be fine, right? If you guys had kids together, if you guys still celebrate, Mother's Day, Father's Day, key events together, if there's a lot of things that you guys could pull together, right? If every single family member, her family, your family can attest, of course, it's a real marriage. Like long distance relationships happen, right? Think about how many truck drivers are constantly on the road. Think about how many people who are pilots who fly around the world. They're not home. Does that mean they can't? They don't have real marriages, right? So just be able to explain and document, and don't rely on just, oh, we have tax returns, we have joint bank accounts, we have a couple selfies together, right?
After biometrics, can reentry permit holders, who are green card holders, leave the U.S.?
Yes.
And do they need to come back to the U.S. before 6 months while their reentry permit is pending?
So the answer is two, right? One is after you do your biometrics and then you leave the country, if you just wait, sometimes you gotta wait a year plus before your green card gets approved. I mean, your reentry permit gets approved, and then your reentry permit is approved for another 2 years, presumably, and you can just come back, 1 month before your reentry expires. So, for example, a lot of our clients, and I'm talking hundreds of our clients who do this, they essentially apply for a reentry permit, stay for 1 month, do the biometrics, leave the country, and stay out for 2.5 years before they come back in with the reentry permit. So, if your question is, will they get in trouble with the customs officer? So far, I'm happy to report of the thousands of cases we've done, they all have successfully entered. A few questions, but no big deal. They all entered. So that is, in a sense, don't have to worry about it. But now here's the second thing. When you apply for your second reentry permit, or your third, or your fourth, or your fifth reentry permit, when they ask in the past 5 years, how long have you left the country? Now you have to say, well, I've been out for 3 years, or 2 years, or 1 year. Then you might only get a 1 year reentry permit. Is that okay? Is that not okay? Everyone's different, right? So if you want to, have a higher chance of getting your 2 year reentry permit, 2 year reentry permit, 2 year reentry permit, you should come back a little bit more often. But if you don't mind, if it's just a temporary thing, if your N470 is already approved and you can get your citizenship really fast, you could do the whole reentry permit and just wait outside for 3 years, come back and apply for citizenship, right?
And how many days before the expiration of the current reentry card can you apply for a new one?
Typically 3 months, usually what we recommend.
And then do you know about how many days it takes to get the biometric appointment?
6 weeks.
And can that be filed online?
No. You will get a biometrics appointment. You can extend it online, but you have to file the reentry permit, not online.
And does being fired or laid off as a green card holder affect naturalization chances?
Yes, the August 2025 memo for naturalization, good moral character analysis does look at your job history. So what they're looking at and what they're, if we're reading between the lines, if you can't hold down a job, you might not have a good moral character that deserves his citizenship. That's what they're talking about. But being fired from a job and then you get another job and then you continue to pay taxes and you're able to support yourself, that's fine. If you're on a 6-month unemployment and then you find another job and you took a little sabbatical, that's fine, right? They're more so looking at, are you a risk to the United States? That's the main idea.
And our last question, so on the second success story, would you say management and USCIS departments are still in a shuffle of new administration priorities?
Yes, absolutely. USCIS is, you say they're in a shuffle. Many people would have used other adjectives about the administration. It's chaotic, and it is not of their own fault at all. If we just look back in the past 5 years, pulling all the Afghan people out and having to expedite process their case, there was so many call outs to attorneys to help. USCIS is like overwhelmed with cases, they need help, right? So Afghanistan issue, Ukraine Russia issue, Israel Palestine issue, now Iran issue, and now all these new executive order issue, and also changing from Democrat to Republican back to Democrat and shifting priorities in different administrations. When the goalpost keeps on changing, new processes are invented, AI, using AI systems, having new responsibility, being deputized by ICE to process cases. It's just a crazy mess. I can't imagine. But again, it's just a job. A lot of things are changing. But I think what you have to understand is these are government workers, right? Government workers are supposed to be insulated from all these crazy changes. But the change that they're going through is probably more existential than any other job on the face of the planet, in my opinion. Like I can't, every few months, another massive wave of changes. These are people who want steady, consistent. They thrive in staying under the radar, not getting anything wrong. But now all these changes are happening. It's all on them. I feel really bad for USCIS officers. Yeah.
Okay, and that is our time for today.
Yep.
On the 751, we have a lot of videos on like the evidence you can provide. So check out our YouTube channel if you want more info, and you can always book a consultation on our website if you have further questions.
Thank you. See you guys later. Bye.
Thanks, everyone. Okay, we will end here and end here. And